Thanks, James. Yeah, thank you very much for the opportunity to publish this chapter in what is a very strong and important collection of papers, and I'm sure it'll stimulate interesting debate and discussion. Unlike many of my fellow contributors, I'm not a legal scholar, so my chapter is not a reflection on refugee law or legal process, but rather what it aims to do is to provide some broader context to those discussions. My contribution to the book is concerned with the conditions that refugees and asylum seekers are exposed to at all stages of the displacement cycle, and how those conditions enable terrorist or extremist groups to operate, in particular to recruit and radicalize among refugee populations. The chapter draws on my research over the past 20 years on the politics of displacement and onward migration in a number of conflicts in Asia, Africa, and Europe, as well as for about the same time looking at the socioeconomic and sociocultural impacts of uprooting and resettlement on poor or marginalized populations. The chapter acknowledges that for more than 40 years now, we have known that extremist and refugee organizations will exploit refugee movements. It's in the Great Lakes, the Sri Lankan Civil War, the Balkans, or more recently in the Middle East. But it argues that over that time we have failed to develop policies or to gain sufficient understanding in order to effectively combat such exploitation and to provide protection to refugees from that exploitation. The chapter argues that if we are to break the harmful connection between radicalization and forced migration, which is something I think we need to do, then there has to be, first of all, a public discussion about that connection. And that must include an improved understanding of how migration histories and experiences can, when they interact with other factors, influence an individual's behavior. And second, the chapter argues we need to do refugee protection and humanitarian operations differently, and perhaps in a way which may include developing interventions that protect displaced populations from the influence of extremist organizations. Now, those interventions may include a range of countering violent extremism programs in refugee settings, but there's a lot of work to be done on what these options might be and how they might work in a manner that doesn't undermine refugee protection. And I'm aware that there is a real risk that they might do that, so I'm extremely cautious about recommending any types of intervention. But in a bid to understand how those conditions that enable radicalization to flourish are, how they are created, the chapter considers the international refugee and humanitarian system and the dynamics of contemporary conflict, including the role of diaspora politics. In relation to the international refugee and humanitarian system, it's argued that the core aims of international refugee and humanitarian law, that states should provide protection to those on the move, that they should ensure that individuals are not returned to situations of danger, and that they should provide legal routes out of danger, are rarely achieved satisfactorily in responses to mass refugee movements, either within the country of conflict, in the region of conflict, in transit to a country of safety, or in a country of refuge where long-term protection is sought, let alone on return home following the assumed cessation of violence. And in the context of weak cooperation between states in refugee settings, and even weaker domestic laws and policies, refugee receiving governments have the serious challenge of balancing the interests and needs of host populations with those of incomers. And this inevitably takes place in a situation of relatively scarce resources, competition for jobs, healthcare, and education. And as a consequence, refugee population over borders predominantly, not all, but the majority, live precarious and temporary lives with insufficient future options. And the hardships are well known, from cramped and insanitary conditions, poor health outcomes, unemployment, and importantly, I think, indebtedness, and a distrust of governments and those international bodies who are frequently blamed for failing refugees in their time of need. So what we have is a situation where displacement and asylum seeking and the movement between countries generates a dangerous cocktail of disaffection and grievance that extremist organizations, through their influencers via social media, are keen to exploit. Recruiters will often offer refugees material support, linking them to others, often organized criminal groups who can arrange passage to other countries, and making a promise to stand by them as they seek to rebuild their lives elsewhere. A few, and it only needs to be a very small number, will or might be drawn to extremist narratives. They might be drawn to these promises and versions of history and current politics that provide a justification for the use of violence to achieve political ends. And in relation to contemporary conflict, the chapter argues that particular forms of diaspora politics flourish in this context of humanitarian failure, organized crime, and extremism. And it's a politics that ensures that a conflict remains alive among overseas populations. And what it tends to do, it's a form of politics that erodes the influence of those, the majority, who would otherwise work for moderation and reconciliation. The chapter draws on a number of case studies of attacks in the UK in 2017. So these are the attack on the Manchester Ariana Grande concert, attacks on London Bridge and Borough Market, and on an underground train at Parsons Green Station in West London. The chapter considers the learning from official reports in those attacks, and it also seeks to identify where migration histories and experiences, drawing on these three cases, where migration histories and experiences, particularly as they relate to different age groups and cohorts of travellers, might be relevant in the profiles of British jihadis, and it offers some thoughts on this. Though it is, I must say, it is speculative because I only had access to limited data. And finally, the chapter considers the effectiveness of aspects of the UK's counter-terrorism strategy, in particular the PREVENT programme, in conceptualising and responding to the connections between migration and behaviour as it's discussed in my chapter. That gives you a sense of what I try to do in this piece, and I'd be very happy to answer questions either now or at some later time. Thanks, James.
Thanks very much, Chris. Our next presenter is Nuala.
Thank you very much, James. I have a presentation to share. So first of all, thank you, James, from our side as well, for assembling all those very interesting chapters and for all your hard editorial work. We know how much work and time you put into this book. And we are happy to present our paper today. So our chapter, sheds a light on a specific national case, which is the case of Switzerland. We analyzed Swiss law and practice concerning asylum applicants who are suspected of terrorism in Switzerland. And you will see in a few instances why we chose the title of Caught Between Unworthiness and Exclusion for our chapter. So I want to begin with a brief explanation of the possible asylum decisions in Switzerland. As in most asylum procedures, as a first step, after an asylum application has been introduced, the authorities, which is in the Swiss case, the State Secretariat for Migration, assess whether the applicant qualifies as a refugee. And that includes assessment whether the person fulfills exclusion grounds based on Article 1F of the Refugee Convention. Although we have to say that we did not find any cases from the Swiss practice where persons who had been suspected of terrorism would have been excluded on the grounds of Article 1F of the Refugee Convention. If the refugee definition is not met, the asylum application is rejected, and an assessment is carried out whether the return of that person would violate non-refoulement obligations of Switzerland based on the Convention Against Torture or the European Convention on Human Rights. If the return of the person would not violate refoulement obligations, then an enforceable return order is issued and the person is obliged to leave Switzerland. In the other case, the person receives what is called a provisional admission as a foreigner, which is a kind of a non-status, and Konstantin will talk about this status in his part of the presentation. But what is more interesting for our analysis and occupies more space in our chapter is the case where a person is actually found to qualify as a refugee, because in this case the assessment doesn't stop yet, because under Swiss law it has to be assessed whether there are possible grounds for asylum exclusion. A person who is excluded from asylum also receives a formal rejection of her asylum application, but will be also provisionally admitted to Switzerland as a refugee. That means her refugee status is accepted, but the person is not granted asylum. Only if no asylum exclusion grounds are found, then the person will be granted asylum. And in practice, and the cases that we analyzed, the most important ground for exclusion from asylum is what is called unworthiness, even though this is an unofficial English translation, and the official languages in Switzerland are German, French, and Italian. So asylum is not granted if a person is considered to be unworthy of asylum due to either serious misconduct or a violation or danger to Switzerland's internal or external security. And to date, the practice in relation to terrorist suspects in the asylum procedure was mainly centered on paragraph A, serious misconduct. Serious misconduct is defined as any act that corresponds to the abstract definition of a felony, and a felony in Swiss law is any offense that is punishable by more than 3 years of imprisonment. And many acts of terrorist nature are considered felonies under Swiss law, and therefore persons who have been convicted in connection with terrorist acts can be excluded from asylum under paragraph A of Article 53 of the Asylum Act. The mere membership in a terrorist group is not a felony as such, only in relation to two groups that have been prohibited in Switzerland, which are Al-Qaeda and the Islamic State. The practice assumes that the mere membership in these organizations constitutes serious misconduct and could therefore lead to exclusion from asylum, even if a person is considered to be a refugee. Now, in 2 years ago, there has been a new judgment of the Swiss Federal Administrative Court, which treated a case where a person had been excluded from asylum under paragraph B of Article 53. And this was, to our knowledge, the first time this possibility had been applied to a person suspected of terrorism, and it has been published as a precedence, and therefore has the potential to alter the practice in substantive ways. This case concerned a person, a man, that had been identified as a member of Kovalen Civan, which is a youth organization of the Kurdistan Workers' Party. And apart from being a member of this organization, he had been participating at a few peaceful protesting activities in Switzerland and had participated had attended a conference of this organization in the Netherlands. This is the only evidence that the Swiss intelligence services had against him. And based on this evidence, they had the suspicion that he was involved in terrorist activities, even though there had been no proven criminal offenses involved. And the applicant himself had not committed any criminal offense. Still, the Federal Administrative Court had held that this evidence was sufficient to exclude the applicant from asylum due to his possible danger to Switzerland's internal or external security. So this case is remarkable because it contains a very extensive interpretation of this term endangerment of Switzerland's internal or external security, and it has the potential to make this paragraph B a kind of a catch-all clause for all security-related concerns in asylum decision-making. This interpretation of security of Switzerland also differs considerably from the term used under international and European law, and it alters the distribution of the burden of proof. And in what we criticize in our chapter is that this is the most important consequence of this judgment. Even though there had not been conclusive evidence that he had been involved in terrorist activities, the court had held that the evidence was enough because he had not been able to prove that he had not been part of terrorist activities. That means the burden of proof is shifted to the applicant, who now has to prove that he was not involved in terrorist activities. And obviously, such kind of negative evidence is notoriously difficult to bring by. And when I listened to John's presentation, it really resonated with me, because when John mentioned the tendency of punishing persons because of with whom they are associated rather than what they have done. And I think this case from the Swiss Federal Administrative Court is very is a nice illustration of this tendency as well. I will now pass the word to Konstantin, who will talk about the consequences of exclusion from asylum under Swiss law.
And this is the second part of our chapter, and it is important to understand that this person is recognized as fulfilling the criteria of the Refugee Convention. So the person is a refugee, but he or she will not basically receive the same status as people that do not qualify for asylum. So we have kind of an in-between exclusion. It's not 1F, but it's just an exclusion from regular residence status. So the person is given a decision where he or she needs to leave Switzerland, and then because of the refugee qualification, the person is given this provisional admission, which is a suspension of removal and not more than that. So the person does not have a regular residence permit, and this is why we call it, it's referred to as a non-status. And in these cases, the integration of these persons is often discretionary, meaning that the local immigration authorities can decide whether the person is free to move within Switzerland. It's only obligatory to let the person have the freedom of movement that would be guaranteed under Article 26 of the Refugee Convention if the person has found a job elsewhere in Switzerland. So these persons are entitled to labor market access and to social aid, but they might be given an order where they have to live if they depend on social aid, and they cannot freely move within Switzerland. So, and they also do not have access to family reunion, because in this case, refugees and refugees that are provisionally admitted are treated differently under Swiss law, and there is a waiting period of at least 3 years and then more integration requirements if you want to have family reunion. And that, you remember Nula's presentation, applies to persons who have not committed a criminal offense, but they cannot prove that they are no terrorists. So if there is intelligence evidence to let's say membership, that was the case at the leading case that Nula presented, of a terrorist associated organization that is not even forbidden in Switzerland, this person may have all these consequences that I just mentioned. And the most important part is that there is kind of a triple barrier to integration for these persons, because first of all, they don't have access to a residence permit. After 5 years, they might apply for a residence permit, but only if they're not a danger to the security of Switzerland. But already in the exclusion decision by the authorities or by the court, you will have the statement that the person is a danger to the internal security of Switzerland. So it's still for the person to prove that he or she is not a danger to Swiss security. If the person would pass this step after 5 years to a residence permit, then it is necessary that the person proves at the next stage for the permanent residence permit again that he or she is not a danger to security. And the third barrier comes then for the naturalization. And there it has to be also, apart from, again, the security question, the person needs also to show that he or she shares the Swiss way of life. And at least at that point, it will be very clearly, because the persons are labeled at some point as unworthy of receiving protection, that the person will not qualify under the new law, under the new naturalization law, to become a Swiss citizen, even though it is proven that the person is not dangerous, because otherwise the person would not even have received a residence permit. And in our concluding remarks, we can see and we identify as general trend to securitization and a control trend. So these persons are kept in a legal limbo situation. And if they ever commit a criminal offense, they will also be ordered to leave Switzerland under a criminal procedure, because since 2016, it is also possible to expulse aliens that have, and that's the Swiss term, that have committed criminal offenses from the Swiss territory, which means that the person will stay in a legal limbo because the person is still a refugee. And we can see that in this case, public safety and order trumps the refugee protection, and it will always be dependent on intelligence evidence from the Swiss Federal Intelligence Service, whether the person is seen as a terrorist or not, and this label will stick to the person. And we have seen that since 2014, there has been a tendency over the Swiss law, and it's in line with the European trend, but still you can clearly identify that also in the decision practice, that security and public safety and order are trumping the refugee protection, and that goes as far as to legal changes to the residency requirements, which means that persons that do not qualify as refugees but might be terrorists are even exempted from a protection against refoulement. Still, these persons could go to the European Court of Human Rights, but under Swiss law, they don't have any protection against refoulement anymore. And for us, this is a worrying trend, because if there is some kind of undisclosed evidence from the Federal Intelligence Service, this will affect the life of these persons for a very long time. And this is what we set out in our chapter. So thank you for your attention, and we're looking forward to questions on that.
Thank you, Nuala and Tino. I'm now going to open the floor for questions to our presenters. Maybe I can ask a general question to all of the panelists. One of the common themes that I'm seeing across all of your presentations and chapters is this whole notion that Tino concluded on, where public safety and order or security trumps refugee protection. So in terms of a balancing of rights, the collective rights in terms of the nation or the community, the state, in terms of safety and security, and the rights of refugees, their human rights in particular, in terms of not only asylum, but also protection. Inevitably, when these two rights come together, it's always the state that prevails. So any comments on that? And a supplementary to that might be, is there any means that could be introduced that could actually support the rights of refugees when these rights, collective rights and individual rights, clash?
Perhaps I can the procedure, the legislation adopted in the UK proliferated, right? As the UK's own attempt to minimize protection for refugees within the EU preceded diminished responsibility by other EU states for refugees. The same thing has happened with the transposition of terrorist legislation to Canada, to Australia, and elsewhere. So what we're seeing is a general move to this type of prevention, this preventative thing, and towards anticipation that people are guilty by their associations, because if they were really guilty, then there would be evidence for a criminal trial. But in the United Kingdom, Canada, and Australia, what's happening is the most of the individuals who are non-nationals, right, are subjected to closed material proceedings. And then it's only a question of guilt by association with minimal evidence, as is occurring in Switzerland and elsewhere. In answer to the second question, it's legislators that have created this law and which have enhanced it and who have enhanced it. So I don't see much hope of changing the situation in the UK, at least, until we're able to change legislators' opinions.
Can I respond to the first part, James? No, I'm not sure if I can be heard. Yeah.
Yes, we hear you.
Can.
Okay, sorry. So, yeah, I mean, I just to respond in a slightly oblique way. I mean, the interesting thing is that I've been writing around international refugee law for several years, but I never actually looked at Article 1F specifically, so not specifically in the context of refugees who are accused of committing terrorist offences. There's another reason why I was very pleased to be involved in this collection. But what I did, what it made me think about when I looked at the case law is that we tend to focus, when we speak of the definition of refugee, on one paragraph of Article 1, traditionally Article 1A2. And the convention is that the conventional exposition is that Article 1A2 contains the definition of the refugee. But in fact, it's Article 1 that contains the definition. And Article 1 includes paragraph F. And so what I found interesting, and in a sense where the working paper, which was the sort of part one of my thinking around this, is that the convention from the start presented a contrasting image of the refugee. And the refugee is Janus face. It's the victim and the terrorist potentially, and that is integral to the definition. And so I think there are some works that are beginning, starting to think is paragraph A paramount or paragraph F and so on. But I think what's very interesting is to note that the refugee as a victim was always contingent. It was always potentially a terrorist, and that's why I think the approaching the question from the perspective as to what level of law preserving violence is legitimate, given in that context, does provide some quite interesting insights. So I hope that's a kind of answer to the question, albeit somewhat oblique. The convention is not inconsistent, if you like, with the state's approach.
I'd like to confirm and build a bit on that, because for me, what we looked at in Switzerland is a tendency across states to find some loopholes to the convention. And the Swiss have done that with their Article 53 in a very obvious way, because this was actually in the beginning, in the 1990s or 1980s, meant as converting Article 1F into a Swiss national law. But then the bar lowered. So Article 1F is never applied because you have a possibility as a decision maker to exclude persons for less evidence. This is why we actually also concentrated on proof. And we can see the same tendency in the decision making of the CJEU, of the Court of Justice of the European Union, because first, they very much concentrated on Article 1FB. And there you need a proven felony, you need a proven wrongdoing of the refugee. And now the court slowly moves to principles of the United Nations. And there the proof and the burden of proof is not so clear. So the burden of proof for the exclusion is not anymore on the state. And this is what also the Swiss case shows. The problem is that actually there was kind of a balancing of rights, because if a state wanted to exclude a person from being a refugee, if the inclusion criteria of Article 1A2 was met, the state had to prove that there is a ground for exclusion. And now this shifts, and this shifts towards like getting the refugee to prove that he or she is not dangerous. And I think that's where the balancing act is dangerous. And from a legal perspective, of course, it is very hard to prove that somebody is really dangerous, but it's on the other side very difficult to prove that you're not dangerous if there is some kind of suspicion. And I think we should look more into these procedural aspects if we really want to look for a balancing act, like James basically said. And I think that would be important procedural protection to arrive, that procedural protection for persons who meet the inclusion criteria is really important in order to safeguard refugee status.
We could be, just to be less optimistic, we could also say that, well, on the one hand, we've seen this process really proliferate after 9/11. At the same time, what we've seen is much higher rejection rates of asylum seekers since 9/11 as well, connected in part to some of this legislation, but also to skepticism of many adjudicators, many asylum judges, okay? So just to be very critical and to cause a question, are the authorities in our respective countries actually undertaking a balanced assessment of refugee applications? Now, if the answer to that is, well, we would need evidence. So what would the evidence be to say that the UK authorities are actually undertaking a balanced assessment of refugee applications? We would need a certain kind of empirical information. We would also need access to the authority. And in the UK, I at least have not been granted access to the Home Office, where I was initially doing an earlier piece of research, but not to policymakers. And it's very clear that the British Home Office is a very insular institution, and that it takes its lead primarily from a conservative with small c, not just the Conservative Party, right, attitude that's been in existence since the early 1990s, which is to say that we are insisting on protecting our borders and our nationals by being tough on asylum seekers, which would seem to have some resonance elsewhere in Europe. So I'd be interested in, Konstantin, to know whether you think the Swiss authorities are undergoing a good balanced assessment of refugee applications.
If I sounded optimistic, that was not what I meant.
Okay.
I meant that the procedural guarantees in this particular area are underdeveloped, because it was very clear for a long time in asylum adjudication that the authorities had the burden of proof for the exclusion ground. And this is shifting. And as this is shifting, there are no procedural guarantees that basically in this court case Nuala presented, it was very clear that the evidence or the basically non-evidence, non-disclosed evidence at least, of the Federal Intelligence Service was enough to shift the burden of proof to the asylum seeker, and the person could not prove that he or she was not involved in any terrorist activities. And that is enough. And I think there should be at least some kind of procedural standard how to decide this, because otherwise it's just sticking, the label is sticking and you cannot remove it.
One of the things that I found very interesting in your chapter, Nuala and Tino, is that your section 53, and I think you said you loosely defined it as unworthiness. Is that correct? So isn't that contrary to the fundamental principles in terms of human rights, where human rights are interdependent, universal, inalienable, and all of the other aspects in terms of human rights? And then, in essence, you're coming to the conclusion in Switzerland that if the person proves unworthy, then they're either going to be excluded or put into this in-between area in terms of exclusion and asylum. So has anyone challenged this very fundamental notion in terms of unworthiness in Switzerland with respect to breaching people's fundamental human rights?
Well, yes. So yes, I confirm your observation that this term unworthiness also it also sounds strange because it has a kind of a moral connotation that should not be a part of refugee status determination. It has not. Well, it has been challenged by the doctrine, but it has not been challenged in court because that is a specific aspect of Swiss constitutional law, because the Swiss federal court cannot overturn anti-constitutional laws. So there's no point in challenging this Article 53 as a whole. There's only possibilities to challenging the qualification of a person as unworthy in an individual case. But yes, I don't know if Tina wants to add something to that.
I just to confirm that and to build on that, this notion of unworthiness is something that is very embedded in Swiss culture in general. You have to behave very well to be fully accepted. And you can see that in the naturalization law, where the Swiss way of life is held up. So it's some kind of this moral reasoning is very much present in the Swiss legal culture. This is why nobody really has challenged this unworthiness, because the Swiss image of a refugee is just the image of a good person. And but another aspect that I also mentioned is they're not taking away all the human rights. The persons are allowed to work and they receive social aid. So, and they're not, and that would be, from my perspective, very much a very European view of the refugee definition. Non-refoulement is upheld, and this is actually what refugees can expect from states. You very much find that a lot in Europe, that there is a focus on Article 33 and not so much a focus on Article 1, which explains to some extent how these provisions play out, because they also exist in other European states.
I wonder if I could welcome Joseph Ritkoff into this discussion, because he's done extensive work, as you probably all know, in terms of comparing different jurisdictions in this particular area. Joseph, do you see any rays of hope in terms of rebalancing the equation between national security and refugee rights and protections? You're on mute, Joseph.
First of all, I've done a comparative analysis. Don't forget that my background is working for a government, so I have an inherent bias, like where I stand. Having said that, I understand.
But you are retired.
Yeah, well, that's true. So I'm softening, finally. But when I look at the developments in Europe, Australia, New Zealand, United States, Canada, the observations made by Nuala and John and Constantine and also Patricia, I'm afraid they are reflected worldwide. Both of the exclusions, general and exclusion related to terrorism, I think that the use of fear against people who might have been involved in terrorism or not is in the ascendant. Like governments are getting not only more vocal about expanding their powers, both in the criminal law and in the refugee immigration law, they're getting also more support from the population. And I think that latter part is even more concerning. I mean, that's the fact that we had in Europe and in the southern United States border so many refugees, and they will be how they're being processed like Sweden, Germany, Netherlands, and France. The population views seem to have hardened. The notion that people prima facie are entitled to refugee status, whether or not have a criminal possible background or not, but in general, that innate sympathy has really, I think, been lost in the last couple of years, partially because of maybe fatigue with refugees, partially people are concerned about losing out to refugees. And that is reflected in how refugees are treated generally, but even more, it's much easier in the particular narrative, the particular circumstances, to look at people and find criminality much quicker than it used to be. So in terms of holding out hope, I think we're not on the right path. I think that those attitudes reflected by Nuala, Constantine, Patricia, and also Christopher, I think are much more widespread than, say, Switzerland or the UK. You see it all over the world. And as a matter of fact, the instances given so far, say Switzerland and UK, they are actually not even all that bad, say, compared to Australia and the United States, I'm afraid. So I'll leave it at that optimistic note.
I'll do one more request for questions or comments from all of those in attendance.
Well, perhaps I can start then, because what's interesting is we've seen a proliferation of terrorism legislation and of closed material proceedings and of a standard of proof required in these, which is very low. So the UK standard of proof is the same as, it's called reasonable suspicion, and it's the same standard that would be used to impose an antisocial behavioral order on a nuisance neighbor. And it's about anticipating crime. But the other side of this is, with all this legislation, there's an apparent increase in terrorist incidents. So I just want to end with a comment or a question, really. How is it possible to balance a government's stated concern with our welfare as citizens with the clearly ineffective nature of terrorist legislation? What is the gap here? Maybe this is precisely what we as social scientists and lawyers should be looking at.
I might have a comment or an addition to that, because I think in Europe there is a tendency to have this terrorist cases very much up in the media, and I see, and I know a bit about Germany as well, at that point where the public discussion on migration is basically on asylum, like in Switzerland and Germany. Also, the discussion on terrorism is very much related to asylum, even though we all know that these cases, because asylum seekers are very much controlled, are very rare, and that the terrorist, let's say, threat is far more in the migration area, or you have homegrown terrorists, and that's kind of far more the danger, but it seems to be emblematic to do that in the asylum area to show that something is done. And this is why I see kind of a symbolic value in that, which is why courts and also parliaments don't dare to introduce better procedural safeguards, because I think it would be like let's say, the nightmare would be that some of these persons who were not found to be terrorist suspects would then commit a crime, like in Germany with the Christmas market in 2016. And I think all courts and parliaments are prepared to do whatever it takes to avoid such an incident again.
Well, I'd like to thank everyone for their participation in this session. Let me begin again. I want to thank everyone for their participation in this virtual book launch. A special thanks, of course, to all our distinguished panelists, and I'd like to thank Joseph Ritkoff and Selena Marsh for joining us for this session as well. It's a distinct honor and privilege to have all of you contributing to this volume, but also for participating in these book launches. So thank you very much for that. For anyone that's interested in this topic, please visit the Brill website where you'll actually find the book there. The book has the foreword, the preface, the introduction, and the index available free of charge, so you can get those online. We're hoping that you would be interested in individual chapters and the entire volume as a whole, of course. And please request your libraries to purchase copies of the book so you can access the book fully. So thank you, everyone, for your participation in the virtual book launch today and our previous one. And for all of you at York University, please join us again for future lunchtime talks at McLaughlin College. We have a number of events and activities throughout the fall and winter terms. And for students, of course, your participation can earn you certificates. So if you attend 6 of our lunchtime talks, you get a certificate. 10 or more, you get the honor certificate, and your name is included in a book draw as well. So there are benefits for attending these talks beyond, of course, expanding your knowledge and accelerating your learning at university. So thank you, everyone. I'm going to be in touch with our contributors later on through email, and I hope to see all of you at our future activities. So thanks so much. I'm going to sign us all off. Hope to be in touch with you shortly. Thank you.
Thank you.